When the employee comes to you with a complaint, you first need to figure out, well, is there a complaint? And if so, what steps do I need to take? Your investigation should again be prompt, fair, and thorough. As I mentioned it earlier, and it's in bold here because it's very important. California law does place a duty on employers to investigate misconduct and take remedial action to prevent further discrimination or harassment from occurring in the workplace. So you want to be sure you're treating all complaints as legitimate until your investigation is completed. Now, keep in mind, employees don't have to use specific words. They don't need to say, I'm being discriminated, I'm being harassed against. There's no key word to trigger an investigation. If that complaint is coming in, even if it seems minor, it should still be investigated and documented. This isn't the stage to determine what the validity of that complaint is or what the corrective action is. That is done after a prompt, fair, and thorough investigation. Now, once that complaint comes in, let's figure out what is the complaint. This requires you to identify the actual complaint from the information that the complainant gave you. You may get a lot of information. You may get very little information. You need to determine what that scope of the complaint is and who the involved parties are. Sometimes you need to ask follow-up questions. You may need to figure out, is this employee venting or are they making a complaint? Has this type of complaint been made by this person or even somebody else? What is the misconduct that the employee is making a complaint about? Sometimes when you receive a complaint, there's a lot of information that may not seem relevant at the outset, but it's important to be sure you're documenting all of the information you receive because it may become relevant later as you conduct your investigation. Throughout your time, you may come across many types of complaints, ranging from minor disputes between coworkers to more egregious sexual harassment claims. It's important to determine what type of complaint is being made so you can take the appropriate steps. Now, as Anne mentioned earlier, this presentation gives us a great framework. It will put together a guide that can be adapted for any type of workplace complainant. For example, if the complaint is about a workplace injury, you may need to look at the OSHA regulations. If the complaint is about unpaid wages, you may decide that you need to review wage statements and time records. No complaint and no investigation is going to be exactly the same. The type of complaint that comes in is going to guide you to determine what information you need, what documents you need to review, who you need to interview, and even who your investigator should be. Now, here are some examples of different types of complaints. And as I mentioned earlier, it could be a very long complaint like this one. Susan is writing a 5-page document that she submits to Human Resources. In her document, she says she's being harassed by her supervisor. She has a disability, her supervisor knows about the disability, and she includes specific dates and examples of each incident. Now, even though Susan may or may not specifically say that harassment is because of her disability, it's still a complaint. It could be because of her disability, it could be because of something else. Either way, there's alleged harassing conduct that needs to be investigated. And it's important to remember that your complaint and investigation may not be linear. This complaint and during this investigation, you may realize, well, is Susan asking for accommodation? Does she have an accommodation? Does this trigger the interactive process? Do we need to have that conversation with Susan to see if she has an accommodation, if she needs one? So some things to keep in mind. Again, not each complaint and investigation is going to be the same. So in this situation, we'll consider whether it matters who the inappropriate conduct was directed at. Nikita reports that she heard Alicia make racially inappropriate comments over the phone while Alicia was taking her meal break. Nikita says that comment wasn't made towards her and no one else was in the break room. Even if the inappropriate conduct was not directed at a specific person, it still may be inappropriate conduct and it still should be investigation. Alicia may have been off the clock and on her meal break, but she was on company property and therefore should still be investigated. Now, what if the inappropriate conduct is unintentional? Does that make a difference? Jesse tells you that John keeps using their wrong pronouns, but doesn't think John is doing it intentionally. In determining whether to investigate, it doesn't matter whether that conduct is intentional. This may be something that you will consider during your investigation, but not at this point. You may look at this complaint and think, hey, here's a simple solution. Let's do some additional training. But the complaint came in and you should still do the investigation no matter how small. You may interview John and he may tell you he didn't realize what he was doing and it wasn't intentional. There may not be any more to investigate past that. Your ultimate conclusion may be to do training, but you can't reach that conclusion until you investigate, until you do your interviews, until you review your documents. Now, what if the alleged wrongdoer is a third party and not an employee? Raquel informs you that one of the delivery drivers for a longtime vendor made sexually inappropriate comments towards her and another employee. Sometimes the alleged harasser may not be an employee, but employers may still be liable for third-party actions and should still take these complaints seriously. This alleged incident happened with a third party, but it involves employees and it is on company property. So you should still investigate. In this case, you may need to involve the vendor. You may complete the investigation and conclude that the vendor needs to have a different delivery driver. Either way, that conclusion cannot be reached without a proper investigation. And finally, does it matter if it occurred on company premises? Hillary tells you that while at an employer-sponsored happy hour, Mark kept trying to touch her inappropriately and she felt uncomfortable. Employers may still be responsible for incidents that occur at company-sponsored events, regardless of whether it's during business hours or on company premises. Here, this was an employer-sponsored happy hour, so there should still be an investigation. During this investigation, you may run into some issues. Maybe not everybody has a clear memory of what occurred. Maybe different witnesses have different perception of the events. This is all part of your investigation. You will need to make credibility determinations to identify what occurred and whether that conduct was against company policy or unlawful.